दोस्तों, प्लेडिंग इन ए सूट अंडर CPC 1908 नया टॉपिक है। हिंदी वर्जन मैंने पहले अपलोड कर रखा है। नाउ लेट अस डिस्कस प्लेडिंग इन ए सूट अंडर CPC. As per Order 6, Rule 1 of CPC, pleading shall mean plaint or written statement. Pleadings are the formal written statements submitted by parties in a civil suit. They lay out the material facts, not evidence, on which the party relies for its claim or defense. The purpose is to क्या आवश्यकता है इसकी? To define the issues in dispute, inform the opposite party, guide the court in framing issues, prevent surprises during trial. It means preventing parties from springing new facts during trial. नए facts लाने का मनाही है इसमें, it prevents. What are material facts in pleading? Under Order 6, Rule 2 of CPC, every pleading must contain a concise statement of material facts on which the party relies for their claim or defense. Second is, it is not the evidence by which those facts are to be proved. It is not an evidence, it is a material fact. Material facts refer to, what do you mean by material facts? The essential facts that form the basis of a legal claim or defense. These are the facts that must be proved at trial to succeed in the case. For example, if a plaintiff is suing for breach of contract, the material facts would include the existence of the contract, the terms agreed upon, and how the breach occurred. It is not the document or witnesses that will prove it. Why is it necessary to plead material facts? The necessity arises from several legal and procedural principles. Number one, clarity and precision. It helps the court understand the exact nature of the dispute. Second is fair notice. It informs the opposite party of the case they must meet. Avoids surprises. Prevents parties from springing new facts during trial. Foundation for evidence. Only facts pleaded can be supported by evidence in court. Judicial efficiency streamlines the trial by focusing only on relevant issues. Failure to plead material facts can lead to rejection of the pleading, dismissal of the suit, inability to present evidence on unpleaded facts. Key principle. There is a principle, plead facts, not law or evidence. This principle ensures parties state what happened, not how the law applies. The court applies the law to the facts presented. Evidence is reserved for trial, not the pleading stage. Plaint. What is plaint? Order 7 CPC, Civil Procedure Code. The plaint is the pleading filed by the plaintiff to initiate a suit. Now, what are the essentials of a plaint? Order 7, Rule 1. It should mention name of the court, name, description and address of the parties, statement showing jurisdiction, facts constituting the cause of action, relief claimed, damages or injunction, etc., valuation for court fees and jurisdiction, verification and signature. What is the purpose of a plaint? It sets the legal machinery in motion, establishes the plaintiff's case, helps the court determine if the suit is maintainable. A plaint may be rejected. Rejection of a plaint. Order 7, Rule 11. A plaint may be rejected if it does not disclose the cause of action. Relief is undervalued. It is insufficiently stamped, or it is barred by law. Written statement. Order 8 CPC. The written statement is the pleading filed by the defendant in response to the plaint. Time frame. What is the time frame filing this written statement? It must be filed within 30 days of service of summons. It can be extended up to 120 days in commercial suits. Beyond that, the right to file may be forfeited. What should be the contents of written statement? Specific denials of allegations, admissions of facts, if any, new facts, fraud, limitations, illegality, set off or counterclaim if applicable. Rules regarding written statement. Denial must be specific. Order 8, Rule 3. Evasive denial is not permitted. Rule 4. Undenied facts may be deemed admitted. Rule 5. Now, I will tell you what is appearance. Appearance refers to the presence of parties in a court, either in person or through a legal representative, that is advocate. It signifies active participation in the proceedings. क्या क्या करेगा ये? Attending hearings, presenting arguments and complying with court directions. जैसा कोर्ट कहेगी वैसा करता है. What is non-appearance? Non-appearance means a party fails to attend the court on the scheduled date, either personally or through counsel. This can have serious consequences depending on who is absent and at what stage. Now, key provisions under Order 9. Rule 2. If plaintiff fails to pay processing fees, then what will happen? The suit may be dismissed. Rule 3. If both the parties are absent, then what happens? The court may dismiss the suit. Rule 6. If defendant is absent and plaintiff present, then the court may pass ex parte decree. Rule 8. If plaintiff is absent and the defendant is present, suit may be dismissed. Rule 9. If plaintiff applies to set aside the suit, there is dismissal of the suit. Rule 13. If defendant applies to set aside the suit, there is ex parte decree. Now remedies available for suit dismissal. Application to set aside dismissal. Order 9. Rule 9. Plaintiff must show sufficient cause for absence. Application to set aside ex parte decree. Order 9. Rule 13. Defendant must prove summons was not duly served or there was sufficient cause for non-appearance. Judicial point of view. This CPC, Civil Procedure Code, emphasizes that no party should suffer due to absence unless justified. Courts generally lean towards allowing parties to be heard, provided they act in good faith and within prescribed timelines. Now, common reasons for non-appearance in the court. Number 1, improper service of summons. The defendant may not have received the summons at all, or it was served incorrectly. This is a valid ground to set aside an ex parte decree under Order 9, Rule 13. Second is medical emergency or illness. Sudden illness of the party or their legal counsel is often accepted as sufficient cause. Medical certificates are usually required as proof. Third is miscommunication or mistake. Confusion about the hearing date or venue. Sometimes clerical errors or misreading of the court notices lead to absence. Fourth is transport or logistical issues. Unexpected delays due to traffic, strikes or natural calamities. It is especially relevant for parties traveling from distant locations. Fifth is death or personal tragedy. Death in the family or other serious personal emergencies. Courts generally take a compassionate view in such cases. Sixth is legal counsel's absence. If the advocate fails to appear due to scheduling conflicts or negligence, the party may not be penalized if they acted in good faith. Lack of awareness or illiteracy in rural or underprivileged areas, parties may not fully understand the legal process. Courts may consider this if the parties show genuine intent to participate. Financial constraints. Inability to afford travel or legal representation. While it is not always accepted, it can be considered depending on the context. Remedy. Application to set aside. If a party fails to appear, they can file an application to set aside dismissal or ex parte decree by showing sufficient cause for their absence. Courts assess this on a case-by-case basis. Now, what is first hearing? First hearing in CPC 1908. The first hearing is a pivotal stage in a civil suit. It occurs after pleadings are complete. That is, the plaint and written statement have been filed and marks the court's first substantive engagement with the case. Necessary requirement for first hearing. Number 1. Completion of pleadings. Plaint by plaintiff, Order 8. Written statement by the defendant, Order 8. Plaint by the plaintiff, Order 7. Written statement by the defendant, Order 8. Any replication or rejoinder if permitted. Second, examination of parties. Order 10. Rule 1. Ascertainment of admissions and denials. Rule 2. Oral examination to clarify pleadings. Rule 1A, 1C. Referral to ADR, alternative dispute resolution, if appropriate. Third, discovery and inspection. Order 11. Parties must disclose relevant documents. Inspection of document may be ordered before the first hearing. Framing of issues. Order 14th. Based on pleadings and examination, the court frames issues of law and fact. These issues guide the trial and determine what needs to be proved. Disposal of suit at first hearing. Order 15. If parties are not at issue on any fact or law, the court may pronounce judgment immediately. If one of several defendants is not at issue, judgment may be passed against them separately. Purpose of first hearing: to clarify dispute between parties, to encourage settlement via ADR, to streamline trial by identifying key issues, and to dispose of suits early if no substantial dispute exists. Judicial point of view: the first hearing is not just a procedural formality, it is a strategic checkpoint. Courts use it to prevent unnecessary trials. It promotes judicial economy and encourages resolution before full trial begins. Thanks for watching this video, friends. If you have not subscribed the channel, please subscribe it. If you have any comment, you can go in the comment box and make your comment. Thanks for watching this video.